To the contrary, no. The ayes have it. Members, we move to Part 2, and this is debate on clauses 6 to 35. The question is that Part 2 stand part. Call Charles Chauvel.
Part 2 of the legislation bill is divided into three subparts. The first of the, it's a bit like Gaul. The subpart 1 deals with publishing legislation requirements and responsibilities. So the Chief Parliamentary Counsel will be required under the bill to arrange for the publication of copies of every act enacted after the commencement of the legislation, copies of all legislative instruments, which is the term that is used in the legislation broadly to describe delegated legislation, and any reprints of acts and legislative instruments, and any reprints of regulations made before the commencement of the section, and finally also reprints of imperial enactments and imperial subordinate legislation in force as part of the laws of New Zealand. The innovation that is required by the bill, or will be required by the bill, is that not only is there to be a definitive written copy of the legislation, which is to be the responsibility for publication of the Parliamentary Counsel Office, but there will be an authoritative electronic version as well of legislation. So Clause 6.2 requires that every Act must be published in electronic form after enactment. 6.3, a copy of every legislative instrument in electronic form. And then the rest of the clause carries on the scheme that I've begun to describe. Then there are provisions around availability, sale of physical copies, availability of electronic versions. There are also provisions around the numbering of legislative instruments and notice of making legislative instruments, all of which are sensible machinery provisions that will assist with the accessibility questions that were referred to in the debate concerning Part 1. And certainly one of the other things that the bill will enable when it's passed is a more logical way of accessing delegated legislation. And that's certainly something that I think people will welcome generally. At the moment, the regulations are well accessible if they're actual regulations in the strict legal term or in the strict legal sense of the term. But there are a whole range of other types of delegated legislation that are much more difficult to access, and it's hoped, I think, that the provisions of the bill will make that sort of thing much easier to locate and read. There's a sensible provision around the power to revoke or otherwise declare ineffective or no longer effective a legislative instrument. That's a power that the Governor-General will have on advice from the Attorney-General. The reenactment of provisions around judicial notice of acts, regulations and legislative instruments. Confirmation around the official status of both electronic and written versions of legislation. And so all those are very sensible provisions, as I've said, and they will, particularly in this age where a whole new generation has become quite accustomed to locating, reading and using material that isn't in printed form at all anymore. It's all simply online. This is a useful, probably overdue innovation, and it's good that a number of years after the Law Commission recommendations around these matters, we're finally moving to enact them. So subpart 2 of Part 2 deals with reprints, some sensible provisions around empowering Chief Parliamentary Counsel to make changes around gender-neutral language, changes around updating references so that references, for example, to Her Majesty the Queen can be automatically changed to references to the sovereign in keeping with contemporary usage. References able to be changed automatically around the content of legislation and schedules. Mr. Chairman, as I say, all measures which make a lot of sense and ought to make for much more efficient updating of our body of laws, and so they are ones that we commend. Probably the most interesting part of Part 2, though, sir, are the provisions around revision bills which are contained in Subpart 3. And I know that my New Zealand First colleague is raring to speak on this particular issue because he's greatly excited by the notion of revision bills. But sir, seriously for a moment, the bill will require that the Attorney-General provide each new Parliament with a draft 3-yearly revision program. And the revision program will be presented to the House as soon as practicable after it's been approved by the government. And basically, revision bills can do a number of things. They can revise the whole or part of one or more acts, and for that purpose combine or divide acts or parts of acts. They can adopt a title that's different from the title or titles of the acts or parts of the acts being revised. They can omit redundant and spent provisions, renumber and arrange provisions from acts being revised or parts of acts. They can make changes in language, format and punctuation to achieve a clear, consistent, gender-neutral and modern style of expression. Include new or additional purpose provisions, outline or overview provisions, examples, diagrams, graphics, flowcharts. Include new or additional provisions alerting users of the revision to enactments that are not incorporated in the revision but relevant to the subject matter of the revision. Correct typographical, punctuation and grammatical errors and other similar errors. Make minor amendments to clarify Parliament's intent and reconcile inconsistencies between provisions. Update monetary amounts for the purpose of jurisdiction. Other than an amount specified for the purpose of jurisdiction or an offence penalty with regard to movements in the CPI. Omit forms and schedules and instead authorise the matters in those forms and schedules to be prescribed by or under regulations. Make consequential amendments to enactments that are not incorporated or are incorporated only in part in the revision, and include any necessary repeals, savings and transitional provisions. Then there are some safeguards that are built into the legislation around revision bills so that they're not able to be misused. There have to be certifications that a bill is in fact a revision bill. The certifiers are the President of the Law Commission, the Solicitor General, a retired judge nominated by the Attorney General and the Chief Parliamentary Counsel. And so this provision relating to revision bills really is an important part of the legislation in respect of the objects that I referred to in my earlier contribution. It will allow for mechanical machinery updating in a sensible way that isn't provided for at the moment, and it's really a very important piece of the bill. It's one that the Regulations Review Committee considered in some detail. We did recommend some amendments, which I'm pleased to see are largely being adopted. One thing that isn't dealt with in the bill, but was dealt with in the Law Commission report, sir, is the necessity to come up with some new standing orders to facilitate the changes that will be made by Subpart 3 when revision bills become a reality. And I'm sure that the Attorney-General has given this careful consideration and is already working with the Office of the Clerk to ensure that there are recommended to the Standing Orders Committee these new standing orders, but they will be required. There was some suggestion that we ought to deal with those machinery standing order type issues in the bill itself, but we, on advice, agreed with the position that that was really a matter for the House. It was for the procedure of the House itself, and that it was something that the Standing Orders Committee would need to come to in due course in order to operationalise. It will be I think a welcome move to see those provisions in particular and those new standing orders come into force, and to see the very commendable innovations that Part 2 will enact, sir.
Mr Chairman.
Call Dennis O'Rourke.
Thank you, Mr Chairman.